A federal judge just revoked Donald Trump's bail and ordered him into custody pending trial. Judge Tanya Chutkin issued the extraordinary ruling this morning after prosecutors presented evidence that Trump violated his release conditions by attempting to intimidate witnesses through social media posts and public statements targeting individuals expected to testify against him. And this isn't some temporary detention for a bail hearing that will be reversed on appeal. This is a federal judge finding that Trump poses such a danger to the integrity of judicial proceedings that he must be held in pretrial detention until his criminal trial concludes, when a federal judge revokes bail for a former president and orders U.S. Marshals to take him into custody. You know, the judicial system just crossed a threshold that will reshape American political history. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what triggered this unprecedented judicial action? Prosecutors filed an emergency motion on January 18th, arguing that Trump had systematically violated the conditions of his release by posting over 40 threatening messages targeting witnesses, court personnel, and prosecutors involved in his federal election interference case. The motion included detailed documentation showing Trump's posts contained specific identifying information about witnesses, threatening language suggesting they would face consequences for testifying, and explicit calls for his supporters to take action against those cooperating with prosecutors. Judge Chutkin held an emergency hearing yesterday where she reviewed the evidence and concluded that Trump's conduct demonstrated a clear and present danger to witness safety and the administration of justice that could not be addressed through modified bail conditions. And believe me, when a federal judge determines that a former president cannot be trusted to follow court orders and must be detained pending trial, the entire foundation of his legal and political strategy just collapsed. Here's the full picture of what's been unfolding. Tensions over Trump's public statements have been escalating for months, with prosecutors filing multiple motions seeking stricter limitations on his commentary about the case. But everything reached a crisis point on January 15th when Trump posted a message on Truth Social that federal prosecutors characterized as a direct threat against a cooperating witness. The post included the witnesses' initials, referenced their expected testimony, and stated that people who betray their country face serious consequences throughout history. Judge Chutkin had previously issued a limited gag order restricting Trump's ability to make statements about witnesses, prosecutors, and court staff. Trump's attorneys successfully appealed portions of that order, arguing it violated his First Amendment rights as a presidential candidate. However, Chutkin maintained restrictions specifically prohibiting statements that could reasonably be interpreted as threatening or intimidating witnesses. The January 15th post appeared to violate those restrictions directly. Prosecutors moved swiftly. On January 16th, they filed a motion documenting not just the January 15th post, but a pattern of escalating violations over the previous 2 weeks. The filing included screenshots of 43 separate social media posts and transcripts of 3 campaign rally speeches where Trump made statements prosecutors argued were designed to intimidate witnesses and prejudice potential jurors. The motion requested an emergency hearing and asked Judge Chutkin to consider revoking Trump's release entirely. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Chutkin convened the emergency hearing yesterday morning at 9:00 a.m. in her Washington, D.C. courtroom, legal observers immediately recognized the gravity of the situation. Federal judges rarely hold emergency bail revocation hearings, intimidate witnesses, and prejudice potential jurors. The motion requested an emergency hearing and asked Judge Chutkin to consider revoking Trump's release entirely. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Chutkin convened the emergency hearing yesterday morning at 9:00 a.m. in her Washington, D.C. courtroom, legal observers immediately recognized the gravity of the situation. Federal judges rarely hold emergency bail revocation hearings, and such proceedings involving a former president were completely unprecedented. The hearing lasted over 4 hours, with prosecutors methodically presenting evidence of Trump's alleged violations, while his defense team argued the statements constituted protected political speech. Here's what multiple sources presented the hearing say happened. Assistant U.S. Attorney Molly Gaston began by walking Judge Tutkin through a timeline of Trump's posts over the previous 14 days. Gaston presented evidence showing that within hours of a witness's identity being disclosed in court filings, Trump would post messages referring to that witness using identifiable characteristics and suggesting they were part of a conspiracy against him. The prosecution argued this pattern demonstrated deliberate witness intimidation. The most dramatic moment came when prosecutors presented testimony from two witnesses who had received threatening messages from Trump supporters after being referenced in his posts. One witness, a former White House aide, testified via secure video link that after Trump posted about presidential advisors who turned traitor, she received over 300 threatening messages within 24 hours, including specific death threats that required FBI protection. Another witness, a state election official, testified that Trump supporters showed up at his home after Trump posted about corrupt state officials who changed vote counts. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. Trump's defense attorney, John Luro, argued strenuously that Trump's statements constituted political speech protected by the First Amendment. Luro contended that as a presidential candidate, Trump had the right to defend himself publicly against what he characterized as politically motivated prosecutions. Judge Tutkin repeatedly interrupted, asking Luro to address the specific evidence of witnesses receiving threats immediately after Trump's posts. The turning point came when Judge Tutkin asked Luro directly whether Trump understood that his release was conditioned on not intimidating witnesses. Luro responded that Trump believed his statements fell within permissible political commentary. Judge Chutan's response, according to multiple reporters in the courtroom, was delivered in a tone described as controlled fury. She stated that Trump's subjective belief about what constitutes acceptable commentary is irrelevant when his actions demonstrably result in stay request, stating that the danger Trump poses to witnesses and the judicial process is immediate and cannot await appellate review. This isn't the first time courts have detained high-profile defendants pending trial for bail violations. Think back to 2019 when Paul Manafort, Trump's former campaign chairman, had his bail revoked after prosecutors proved he attempted to tamper with witnesses while on release. The judge in that case concluded Manafort posed too great a risk to witness safety to remain free. Manafort spent months in detention before his trial and eventual conviction. Then consider 2023's case involving former crypto executive Sam Bankman-Fried. He initially was released on bail but had that revoked when prosecutors showed he had attempted to contact witnesses and intimidate them through intermediaries. The judge found that no bail conditions could adequately protect witnesses from someone with Bankman-Fried's resources and determination to obstruct justice. He remained in detention through his status or resources. Now, however, the situation involves a former president of the United States. Trump's attorneys argued that detaining a major party presidential candidate raises unprecedented First Amendment and political concerns. But Judge Chutkin's ruling makes clear that constitutional protections do not extend to witness intimidation regardless of the defendant's political status. The pattern is undeniable. When defendants use their platform and resources to threaten witnesses and undermine judicial proceedings, courts will revoke their freedom to protect the integrity of the justice system. So what specifically led Judge Chutan to take this extraordinary step? According to the written order she issued immediately after the hearing, Trump's conduct over the past 2 weeks demonstrated a deliberate and systematic effort to intimidate witnesses through public statements designed to identify them to his supporters, and suggests they should face consequences for cooperating with prosecutors. The order cites specific orders say Chutkan specifically rejected arguments that Trump's status as a presidential candidate warranted special treatment, writing that the rule of law requires equal application regardless of a defendant's political prominence. Here's the kicker. The order directs U.S. Marshals to transport Trump to the Federal Correctional Institution in Alexandria, Virginia, where he will be held in a secure unit pending his trial scheduled to begin March 4th. The facility houses pretrial defendants in criminal charges can use their public platforms to identify and threaten witnesses without facing detention. The entire witness protection system and the ability of courts to ensure fair trials collapses. Once that precedent is established, wealthy and prominent defendants could effectively intimidate their way out of accountability. This puts Trump's presidential campaign in an impossible situation. On one side, he now faces the reality of being detained in a federal facility while running for president. Campaign events will be impossible. Fundraising will occur from detention. His ability to participate in debates, give speeches, or conduct normal campaign activities effectively ends. On the other side, he must maintain claims that this detention is political persecution, while a federal judge has documented 43 specific instances of conduct that violated his release conditions. And here's the political and legal crisis this creates. There's no immediate escape. Either Trump's attorneys convince an appellate court to overturn Judge Chutkan's detention order, which legal experts say is extremely unlikely given the detailed factual findings of witness intimidation, or Trump remains in custody through his trial. His argument that these prosecutions are politically motivated witch hunts becomes harder to sustain when the detention results from his own documented conduct threatening witnesses. Legal analysts and former federal judges are calling this one of the most significant bail revocation rulings in American legal history. Former federal judge Nancy Gertner, now a Harvard law professor, told CNN that Judge Chutkan's decision reflects standard legal principles applied to an extraordinary defendant. Gertner explained that bail revocation for witness intimidation is routine in federal court when prosecutors present clear evidence of threats. The unprecedented aspect is not the legal reasoning, but rather the defendant's identity as a former president. Do me a favor and slam that like button because it genuinely helps this video reach more people. Former federal prosecutor Renato Mariotti told MSNBC that Trump's detention demonstrates the principle that no defendant is above the law or the conditions of their release. Mariotti emphasized that federal judges have broad discretion to revoke bail when defendants violate release conditions, and appellate courts rarely overturn such decisions when supported by factual findings of witness intimidation. Even Alan Dershowitz, a constitutional law scholar who has defended Trump on legal issues, acknowledged in a Wall Street Journal interview that Judge Chutkan's ruling appears legally defensible if the factual record supports findings of witness intimidation. Dershowitz noted that while he questions whether some of Trump's statements cross the line into intimidation, courts generally defer to trial judges' assessments of witness safety concerns. So let's break down the immediate implications. First, Trump will be transported to federal detention within hours of the ruling. U.S. Marshals have jurisdiction to execute Judge Chutkan's order immediately. Trump will undergo standard intake procedures at the Alexandria facility, including medical screening, property inventory, and assignment to a detention unit. Legal experts note that as a former president with Secret Service protection, Trump will likely be housed in a secure unit separated from other detainees. Second, Trump's campaign operations face unprecedented disruption. All campaign events scheduled through the trial date are of appeals. However, appellate courts apply an abuse of discretion standard, meaning they will overturn the detention order only if Judge Chutkan's factual findings are clearly erroneous or her legal conclusions represent a significant error. Given the detailed record of Trump's statements and the testimony about threats witnesses received, legal experts consider reversal unlikely. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. Or But beyond the immediate political ramifications, this detention addresses fundamental questions about whether the judicial system can function when defendants use their platforms to intimidate witnesses. Witnesses testify under oath at great personal risk when they provide evidence in criminal cases. That testimony serves as the foundation of the adversarial justice system that defines American criminal law. If defendants can identify witnesses publicly and encourage their supporters to threaten those witnesses without facing detention, the witness protection system becomes meaningless. Witnesses will refuse to testify rather than face death threats and violence. Criminal prosecutions will collapse when evidence cannot be presented because witnesses fear for their safety. The ability of courts to conduct fair trials depends on protecting witnesses from intimidation. This situation has created absolute chaos within Trump's campaign and legal team. Multiple sources report emergency strategy sessions occurring throughout yesterday and today to determine how to respond to detention that removes Trump from the campaign trail for potentially months. Some advisors reportedly argued that the detention would galvanize Trump's base and prove his claims of political persecution. Others expressed alarm that images of Trump in detention would alienate swing voters and independents. The campaign faces impossible messaging challenges. Reports indicate internal debates over whether to emphasize Trump's detention as martyrdom or attempt to minimize discussion of his circumstances. Trump's social media team faces the reality that Trump cannot post directly while detained, fundamentally changing his communication strategy. Campaign managers must reimagine how to maintain momentum when their candidate cannot appear publicly. Meanwhile, Trump's core supporters are reacting with fury to what they characterize as judicial tyranny and political imprisonment. Social media platforms show widespread calls to protest Trump's detention, demands that Republicans in Congress intervene, and conspiracy theories claiming the entire proceeding was orchestrated to eliminate Trump from the presidential race. Trump's bail revocation, judge's historic ruling, could change everything.